Each day, the cost of living is increasing. It is the same as funeral and cemetery costs. Pre-plan your arrangements today and save your family the stress of finding the money later. Finance your plan up to 7 years with low down payments and affordable monthly payments. To set up your appointment, call Kathleen Barreau at 786-253-0211. 786-253-0211.
Nou menm pa haïtien, lè nou fin grandi ti moun nou yo, nou ba yo edukasyon, yo jwen bon job, yo vin fonde fami yo. Ki sa ki ka arrive nan vie jou yo? Ti moun nou yo a paye bil pa yo, petit yo pral l'école, esko deja prepare anteman ou? Pa kite ti moun nou yo nan problem, rele Kathleen Barreau nan 786-253-0211 pou l'ka edo prepare zafè anteman ou. Pa kite petit yo ap chèche l'ajan nan mes ami, rele Kathleen Barreau dans 786-253-0211. 786-253-0211.
All right. Bonsoir tout le monde. Bonsoir pour tout le monde. Bon après-midi. Let me not jumble up my words. Bienvenue à Chat with Kat. You are listening to WSRF 1580 and 99.5 FM. I am your host, Kathleen Barreau, for the next 30 minutes or 28 minutes if you want to be technical. I am very, very, very much looking forward to the show. I have a very special guest. I've been trying to get him on my show for a little bit. As you guys know, I am in the death care industry, and my special guest, we go hand in hand. He kind of lays everything in the foundation, and then I kind of pick it up and then go from there. So I have a very special guest. His name is Jason Neufeld. He is an elder law attorney. I'm not going to say too much. I'm going to give him the opportunity to introduce himself. Jason, thank you so much. Welcome to Chat with Kat.
Kat, it is such a pleasure to be here. I'm glad we were finally able to get our schedules together, and I'm thrilled to be on your show.
I think we have a little small technical difficulty. 1 second. Oh, no. Hold on, Jason. You hear me?
I hear you.
Okay, perfect. Okay, thank you so much. So like I was saying, thank you so much for being on this show. I've really been looking forward to the show all of September, part of August, and you're finally here. As I mentioned to the audience, you know, we go hand in hand. I handle death care, and you kind of lay the foundation before and after. So without further ado, guys, we have Jason Neufeld. He is an elder law attorney. I don't want to take, I want you to introduce yourself since you're my feature today. So welcome to the show, Jason.
Thank you so much. I'm thrilled to be here. I'm glad our schedules were finally able to get together.
Right.
And I'm happy to chat and talk to you and your listeners about anything that we do. So I'll lay it out in 30 seconds. Essentially, we do 3 different areas of law. We do estate planning, so that's making sure that you decide who can make decisions for you if you can't make decisions for yourself, and who gets your stuff in the most efficient way after you pass away.
Exactly.
And hopefully being able to avoid that court process.
Oh, yeah.
So that's estate planning.
Exactly.
Then there's probate, which is if people who haven't planned properly, then they have to go to court, and we can walk people through that process as well. And then what we do that's, I think, a little bit different, a little bit more nuanced is Medicaid planning, where we work with people who need help paying for care, and we can legally and ethically protect their assets and help staying home for longer, getting care paid for, or if they need to be in a facility, getting the government to pay for a substantial portion of that facility. That's what we do.
Exactly. So I initially met you through Erda Duman. Erda was actually my very first guest. I had to.
Erda's terrific.
She's amazing, and she's actually helped me and my family as well as some of my peers. So to dive into it, what exactly is elder law? I know that what you do encompasses what you just mentioned, but for those who, like me, I'm a caregiver, who has their mom and dad and they take care of them. So essentially, what is elder law? Can you let us know what that means?
Yeah, it's all these different things. So it's estate planning, it's probate, it's Medicaid planning, sometimes it's guardianship. It's not always working with the elderly, but it's mostly working with the elderly. So I work with either those who are elderly or are disabled. So maybe they're not over the age of 65, but they have need for care. And essentially, I think that's what makes estate planning attorneys different, Medicaid planning attorneys and elder law attorneys different than just general estate planning, right? So we work with people and their caregivers, such as yourself, and a lot of people come to us or their caregivers come to us because they're stressed out, right? They are stressed out caring for their loved one. They're stressed out paying for the care and affording the care for their loved one, and they need help. And so they come to someone like me, and we're able to rearrange their assets in a way to allow the government to come in and provide them literally financial assistance with paying their help. We can get caregivers paid by the government, or sometimes, for example, Kathleen, you work and maybe you can't be home to be the caregiver all the time, but maybe they'll allow you to be able to work. We get the government to pay for someone else or an agency to come in to provide that care.
Wow. So are there any legal issues that seniors or their family members should be aware of as they age?
Yeah, I think I tell people that of all the fancy planning that I do, the most important document I can provide someone that a lot of people take for granted is a good Medicaid compliant durable power of attorney.
Oh.
So the power of attorney, a lot of people think is a one-size-fits-all document. They can download it off the internet and that it'll be fine, and it lulls them into this false security because the power of attorney that you download off the internet might be good for certain things, but most likely it's not going to give you or your caregiver the ability to do everything that's needed as we get more and more complicated planning tools, right? And so what happens is if you have a no power of attorney or a insufficient power of attorney, and now let's think about our elderly loved one who doesn't have the right document in place. They lose their ability to make decisions for themselves. And now they're relying on their son or their daughter to make decisions for them, and they don't have a good document in place. Now they have to go to court. They have to get a judge to say, unfortunately, we don't have the ability. I, Kathleen, don't have the ability to make decisions on behalf of my mother because the power of attorney either doesn't exist or it's not good enough to do what we need to do. And now we need the judge to get involved to decide who's going to be able to make decisions for mom.
Now you touched on the power of attorney. I'm so good. And Erda knows this, and I'm okay to tell on myself because I feel like if I'm gonna offer you something in our field, I should I should try it out on myself. So I'm guilty for like downloading things off the internet, and one of the things I did.
Good company. Lots of people do it.
So I downloaded my power of attorney for my mom, and you said something that sometimes power of attorneys can be insufficient. What qualifies it to be so?
Yeah, so here's what happened. A long time ago, back before the law changed in 2011. Okay, that's when there was this big change in the law. Before 2011, you could have these very generic power of attorney forms that say, I name Kathleen the ability to do everything for me, so help me God. You didn't have to be very specific. Okay, you just say, Kathleen can do everything for me as Kathleen's mother, and that was it. As long as it was signed by two witnesses and a notary, you were good to go. After the law changed, great specificity became required. Meaning, if it's not in there, you can't do it. You can't use this very generic, I just give my agent the ability to do everything for me, whatever it is. So we have to be very specific. And there are certain items that if they're not initialed properly, even if it's in black and white, you still wouldn't be able to do it. So that's why it lulls people into a false sense of security. Like your power of attorney, I haven't looked at it, but and I'm happy to look at it for you. I can almost guarantee that it's going to be good enough for things like banking. Right? You take money out of the account and pay mom's bills and do those sorts of things. But my fear is that if she has some assets, and you were to say, Jason, I'd like to talk to you about how we can get mom help paying for more care, getting me paid to provide her care, I would look at that power of attorney and I might say, we have all these great planning options that are more complicated than just moving money in and out of a bank account that we can't do because your document is insufficient. So it's good for certain things, not good for other things. It might be great. Again, I haven't seen it. I don't know. But I see a lot of these forms online as being inadequate.
Okay.
So what we want to do is if your mother signed a form that we don't like, while she has her mind, if she still has her mind, we'd want to get her to sign a new Medicaid compliant, more expansive durable power of attorney.
Okay. Now, can you explain the importance of power of attorneys and healthcare directives? I try to preach that gospel of having healthcare directives when I meet with families for their pre-need funeral arrangements. Can you expand upon that?
Yeah, absolutely. So the idea is, I call this incapacity planning, right? While you have your mind and can communicate, no one cares about what anyone else says about the matter, right? I'm just using you as an example, Kathleen, and let's say you're taking care of your mother, okay? While your mother has the ability to communicate and make her wishes known, it doesn't matter what a healthcare surrogate designation says. It doesn't matter what her advance directive says. The doctor's going to talk to her, and they're going to ask her for her opinion as to what medical care and her input, right? They don't care what you have to say.
Right.
If she loses the ability to communicate or make decisions for herself because she has dementia or Alzheimer's or whatever the case might be, now we want to make sure we have the right documents in place where your mother has decided, here's the person I trust to be able to make decisions for me. Dealing with the doctor, accessing my medical records, consenting to surgery, withholding treatment, depending on what life circumstances bring our way. So incapacity planning, the essential incapacity planning documents in my mind are the durable power of attorney, because that's dealing with contracts, dealing with banking, dealing with the government, dealing with real estate, getting bills paid, right? That's certainly very important. And then the healthcare surrogate designation is how you deal with accessing medical records and making medical decisions. And then we have what's called a living will, which is not the same as a last will. They sound similar, but it's different. Last will is who gets your stuff after you pass away. A living will is a health decision making document, which is if you're at the end of your life, if you're in what they call an end stage terminal condition, right? You're alive, but you're not alive. You're alive because you're connected to machines. What do you want to happen at that point in time? And there's no right or wrong answer. There are some people who say, if I am in this position and there's no reasonable likelihood of me coming out of that position with measurable quality of life, then I want to be kept pain-free, kept hydrated, and let me go. Right? Don't take extra efforts to keep me alive because I don't want to subsist that way. Other people, which is a fine position to take, maybe it's for religious reasons, say, you need to do whatever it is you need to do to keep me alive. I don't care how painful it is. I don't care if it means I'm only alive for another 5 minutes, because maybe they run in with the cure after 2 minutes, right? So these are the important documents that everybody needs. Even if you don't have any assets to your name, if you don't own any real estate, if you have no money in the bank, you still need these very important incapacity planning documents.
Okay. Let me ask you this, because I worked at a funeral home, a very well funeral home, and I'm sure you and that funeral home owner are still friends. There was a situation where the deceased had passed, and the family, or the family, well, not the family, but the next of kin had like a post power of attorney. Can you talk about that too? Like, is there?
There's no such thing.
There's no such thing.
A power of attorney passes with the person who signed it. In other words, there's no such. What happens is. That's why you might want something like a revocable living trust, right? That's where assets can be for the full benefit of the individual while they're alive, and then immediately when they pass, it can owned or in control of somebody else to pay bills like that.
Oh.
But it's not a power of attorney. A power of attorney is no good after somebody passes away.
So that's it. Once the person passes, it's null and void. It's useless.
Exactly.
And there's no such thing as a post power of attorney. Oh, wow.
You either have to go to court or probate if you don't have a trust, or you rely on your trustee, which is who you've designed to take control over your assets after you pass away, if you have a trust. Otherwise, even if you're relying on a will, and the will says, this is the person that's my executor or personal representative, they can't do anything until a judge says so. So, yep.
Amazing. All right, so let's switch gears and let's go into wills and trusts. I know, again, I'm guilty of Google, but I have yet to go on Google and get a trust. I probably will leave that to you because some of the things that you're saying, I'm going to actually use you to help myself out. So can you tell us the difference between a will and a trust?
Yeah, I would love to.
Thanks.
Very common cause of confusion. They're important documents, and in my mind, if you want to make sure that your family does not have to go to court to get access to your assets, you want a trust. They both essentially say the same thing. The will and the trust are going to say, here's who gets my stuff after I pass away. Okay, on the most basic level. The trust is going to have more complexity. The trust is going to have more contingencies. We're going to get into that in a moment. But when we boil it down, it's who gets my stuff after I pass away. If you're relying on a will, you're going to court, or your kids are going to court. Right? A lot of people have the misconception. They go, I have a will, so I don't have to go to court. That's what a lot of people think is true. That is 100% false. A will doesn't do anything for anybody until it's presented to a judge.
Oh, wow.
Okay? So, if you want to avoid going... Now listen, sometimes there are ways to situate your assets so that it doesn't really matter what the will says or the trust says. So for example, with a bank account, you can name a pay-on-death beneficiary of that bank account, right? You can do that, right? If you have a Bank of America account, just to use, any big name example, you can go into Bank of America and fill out their paperwork and say, I want to name this person to receive all the contents of this bank account upon my passing, and then it wouldn't matter what a trust says, it wouldn't matter what the will says, that will go to that person after the account owner passes away. The issue with that is, what if you want the money going to multiple people? What if that person passes away before you? What if that person who you want to inherit your money after you pass away becomes disabled themselves? They get into a car accident, they have a stroke, they have a heart attack, and now they shouldn't be receiving money, because if they receive money directly, it would negatively impact their ability to qualify for long-term care benefits like what Medicaid offers. We'll talk about that in a moment. But so relying on a will and relying on a pay-on-death beneficiary doesn't protect against these multiple contingencies, whereas with a trust, you can have the benefit of making sure you avoid court, your heirs having to go to court, and then you can say things like, well, let's say I have 3 children, and I pass away, and by the time I pass away, one of them, right? If my child who predeceases me has children of their own, I might say, where normally my assets would have been split 3 ways, but because one of them has passed away, I want that 1/3 share to go to their children, right? The trust provides for things like that while being able to avoid court. The trust provides for, if anybody who normally would be inheriting money is themselves disabled, even if they're not disabled now, they become disabled later on, then instead of them getting the money outright, which would negatively impact their ability to qualify for benefits, they would instead, that money would go into what's called a special needs trust, where they could still enjoy it, they could still benefit from it, it could still improve the quality of their life, but it wouldn't count against them when determining their eligibility for these government benefits.
Interesting.
Trust gives a lot more protection.
Oh, yeah.
My position is, if you own a house or a condo, you need a trust. It's just that's kind of a lot of people think trusts are just for the wealthy, and it's really not. It's really not. If you own real estate, which is a significant asset, and you want to make sure that asset avoids probate, a trust is going to be the most efficient way of doing that. And certainly, if you have substantial assets and hundreds of thousands of dollars in the bank and life insurance policies and retirement plans and things like that, a trust can be the way you corral all those assets together and get it to where you want it to go in the most efficient way possible. But even people
Nice.
who have very little money in the bank, if they just own a house, they would still benefit from a trust.
Okay. Now, what are the, I guess, severities of someone not coming to you or an attorney to get a trust, and now they have to go through probate?
Yeah, if they go through probate, it's not, probate's not even the end of the world. It's just more money and it's time. I mean, even an easy probate where everybody gets along, no one's fighting over everything, and the will's very clear. It says, after I pass, it goes to my three kids, whatever the case is. An easy probate's going to take 9 months, a year. So you're waiting for a long time, and there's extra costs involved. You have to put creditors on notice. You have to publish things in the newspaper about the passing. So it's a very public event as opposed to it staying private. So there's the cost of having to hire an attorney, because every probate requires you to hire an attorney. Right? So you have to hire an attorney who's going to charge some, $2, $3, $4,000, whatever the case is, depending on how much money's involved, and more if there's more substantial assets. So you're spending more money and you're waiting. So there's the time component and the money component. You can save money and save time by avoiding probate through a revocable living trust.
Okay. Can a trust be updated from time to time, or is it just set in stone? That's it.
It's a beautiful question. I love that question. The answer is, as long as the person who created the trust has their mind and are alive, obviously, they can amend that trust anytime they want. And I like people to think about it as a revocable trust is basically an instruction manual. And while you are alive, you can change the rules anytime you want, right? There's rules to the game, and it's your money. You can do whatever you want with it and change the rules and change who gets what. And what happens is after you pass away, that's when the revocable trust, which is amendable, becomes irrevocable and non-amendable. So when you pass away, it's locked in stone at that point in time. But while you're alive and can make decisions, it can be amended at any time.
Okay. What are some common pitfalls that folks make when setting up their trusts?
The most common is, so for example, when we set up a trust, people are sometimes under the false belief that the trust has, and I'm smiling as I say this for the people who are just listening on the radio, the trust has this magical component that sucks in assets automatically just because there's a signed piece of paper, right? Just because the trust is signed, witnessed, and notarized, you have to go through the extra step of getting the assets into the trust. So how do you do that? With real estate, we would do that for the client, right? We would have the client sign a deed that would get the property out of their name and put it into the name of their trust. So we would handle getting the real estate into the trust for them. And by the way, they don't lose homestead, they don't pay anything else in taxes, there's no real difference to their life while they're alive. So there's no drawback to doing it. But with things like bank account, Bank of America won't talk to me. So what we do is we give our clients instructions, both verbally and in writing. We go, you have to take this trust, and we give them what happened. The trust is, let's call it 30 or 40 pages long. We give them this 2-page, what's called a certificate of trust that all third parties have to honor. We give them instructions. You take the certificate of trust, you bring it into the bank, and you say, I want to either rename the account in the name of this trust, or I want to list the trust as the pay on death beneficiary. And they have to do that with every account, every life insurance policy, every retirement account, every investment account, right? Everything that they have to take some additional effort to get the property into the trust now, or set up so the institution knows that the property is going to go into the trust after the account owner passes away. So what happens is sometimes after we set someone with a trust, we give them instructions and we follow up with them. So we know it gets done properly after they're done working with us. But let's say 5 years goes by, 10 years goes by, and they forget all about me. They forget all about Jason. They forget all about their trust because, again, there's really going to be the way they operate their life isn't going to be any different because they have a trust. It's going to, everything, they pay their bills the exact same way. It's, there's really no big deal there. But let's just say 5, 10 years goes by and someone goes, I found this really attractive CD that's paying a really high interest rate at this bank somewhere. And they go and they put $10,000, $25,000 into a CD and they forget to open up the CD in the name of the trust, or they forget to name the trust as the pay on death beneficiary. And then they pass away. Well, now we have a situation where some assets, whatever made it into the trust, avoids probate, and we have this one asset that doesn't have a way to make it into the trust, and now we're relying on the will. We have to go to court for that one asset, which is very frustrating. But if it has to be done, it has to be done.
I see. Are there any recent changes in elder law or estate planning that listeners should be aware of, like any new trends or anything like that?
Nothing. I think nothing particular. Let me think. Any recent changes in the law? I'll tell you, people violate that 13-year-old change in the law all the time. But there's a lot of bad powers of attorney out there. So the people are operating these old powers of attorney that are no longer in compliance with the law. So that is something that we see a lot of. As far as there are always little changes. So what the impact of those changes is, we adjust the verbiage in our documents to reflect those changes, but the net effect isn't of the same net effect is experienced by the client. So that's just, we keep up with the laws because that's important, that's what we have to do, and then we make changes so the client doesn't need to worry about it.
So I'm going to ask you 2 questions. And that's the final 2 questions of the show. I really wish I could keep you forever, but I can't.
I'm happy to come back if you'd like me to come back. I've very much enjoyed this, by the way.
Thank you. I will definitely be sending you an email.
Okay.
Question, what advice would you give to someone who's just starting out to think about estate planning or elder law issues? So what advice would you give?
I would say, it's first of all, anybody who has children or owns property should have some kind of an estate plan. Even if they don't have property and they don't have anything resembling substantial assets, they need an incapacity plan, right? The power of attorney, the healthcare surrogate, the living will, those are important no matter who you are. If you're an adult, your spouse doesn't get to make decisions for you just because they're your spouse. Your children don't get to make decisions for you just because they're your children. You need these legal documents in place. On the Medicaid or elder law side of what we do, I deal with a lot of people who don't realize that there is help out there. There's a lot of caregivers who are suffering in silence. They're struggling financially, they're struggling emotionally.
Yep.
So I always try to provide people with access to resources, whether it's emotional resources like support groups or financial resources, right? Let's not have mom or dad run out of money before we get them on government benefits. If you are putting your own money into caring for them, let's get you some assistance with that. And there's a lot of bad information out there. That's one of the reasons why, for the people who are watching online, I wrote a book. And so if you're not ready for a consultation, this book, it's like, I forgot, $7 to $15 or something like that online. There's an audio book. And it's called How to Get Medicaid to Pay for Some or All of Your Long-Term Care Expenses Without Having to Sell Your House, without having to wait 5 years, without having to go broke first. So that's just something available. I try to put out really high quality information on my website and YouTube channel, which is just elderneedslaw.com or @elderneedslaw on YouTube. And again, there's nothing salesy about it other than here's my phone number. If you want to call me, of course, we're happy to help, but I'm trying to get out good information to keep people informed. And I want to put out as much free or low cost information as I can. I do free webinars on the website. So I want people to check all that stuff out, educate themselves, And if they don't have to contact me. If they want to contact somebody else, I'm fine with it, but I want them to at least know what questions to ask. If they're in Florida, we're happy to help. If they're outside of Florida, I'm happy to refer them to an attorney who can help them in that other state.
Jason, really quick, how can the listeners get in touch with you really fast?
Yeah, so the main office number, I'll use the one that's on this banner here, 786-756-8169, 786-756-8169. We have a bunch of different numbers. If you went on our website, you can see some other ones. They all go to the same central intake. And they can reach me directly at jason@elderneedslaw.com or on the website, elderneedslaw.com, or the YouTube channel. People ask questions and I respond to the questions on YouTube. And these are lots of different ways to get a hold of me.
Perfect. Thank you so much, Jason, for being on the show. Thank you guys for listening to our show, Chat with Kat, on 1580 AM 99.5 WSRF 1580. I'm speaking really fast because we're over our time. I want to thank you so much, Jason, for listening, for coming on the show, and thank you, listeners, for being patient and listening to the show as well. Have a great weekend, you guys. Stay safe, stay dry, and guys, take proper precaution for the storm. Have a great night. Good night.
Thank you.